Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention. The court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning, everyone. Before I call today's case, I want to thank our hosts and welcome our students and educators. More than 400 students are participating in this historic event, including students from Traverse City Central and Traverse City West Senior High School. And my colleagues and I very much appreciate the opportunity to be here today. Thanks also to the Grand Traverse, Leelanau, and Antrim County Bar Association, the attorney mentors, the students, the educators, and the community members for your support. The court appreciates all of your efforts. Without our local partners, the court could not have this Community Connections program succeed. This is the 25th such program for the court, and as is the case with all of these events, we are completely dependent on the local bench and bar and community for their support, and you all have shown us fantastic support. A special thank you goes out to the Traverse City manager, Marty Coburn. Marty initially sought our appearance here, and he has been a driving force in what you will see here today. Thank you, Marty. And we are also grateful to the Michigan State Police, Cadillac Post, and the Traverse City Police Department. Today's argument is being live streamed, so viewers can watch it anywhere in the world. So welcome to anyone who's watching via live stream. You've already been asked to turn your phones to silent or turn them off. We appreciate that. We're looking forward to seeing you at the reception afterwards, and we can have as many photos as we want at that time. But for the sake of the advocates here, let's keep our phones in our pockets. Following the argument, we're looking forward to seeing you. Well, first, before we see you in the auditorium, you're going to have a debriefing here with the council, and they're going to be able to answer your questions about the arguments. Our Chief Commissioner, Dan Brubaker, is going to moderate that discussion. Dan actually was a student at this high school. Many, I'm just kidding, Dan. But at some point, he was a student at this high school, so it's he's excited to be back here and to facilitate that discussion. Oral argument that you'll see today is a key part of appellate decision-making. The process that we use here is important. It helps us determine not just the outcome of the case, but how the opinion we write, how to write it, and how it will affect future cases that lower courts are bound to follow. We've all read the parties' briefs. We've all studied the law that affects the question here, just like you have. And the questions we ask during oral argument are designed to help us with that process, to help us figure out how to craft an accurate and clear statement of the law that will help parties going forward, not just the parties in this case. Our goal is to leave you better informed about the rule of law, its role in our constitutional democracy, and we are grateful for your interest and engagement in the court's work. And with that, I will call today's case, Maniaki versus Dieroff. This is a motion on the mini oral argument on the application. You have 15 minutes. You may try and reserve some if you like, Mr. Eliason.
Good morning, Philip Ellison, appearing on behalf of the appellants. And I will, again, control my own time as best we can, but I suspect it's going to go fast. Your Honors, today the issue that's before you, obviously, I'm going to be a little more detailed because we have our audience here with us with some information in my background, but this case comes to you from the Gladwin County Circuit Court, and on the morning of trial, the parties reached a resolution of the case. And the resolution of the case affected not only my client, who was there before the court, but everyone that lived in that particular neighborhood. Because the parties agreed that the owners of Lot B, adjacent to Vonda Lane, and on the other side, adjacent to the Tibbetawasi River and or sometimes known as Secord Lake in that particular area due to the dams, provided that there was a road, there was two parts, primarily. The first is, which seems to be missed by all the parties, is an ingress and egress access to and from not Vonda Lane or Parcel B, but the Tibbetawasi River itself. It provided riparian right access. Secondarily, to further define those rights, the parties, through their consent judgment, actually agreed that they would provide also for the temporary mooring, basically anchoring a boat, but also, which is key to this particular case, is the launching of watercraft including by boat trailer. Launching a boat by boat trailer is a commonly understood Michigan activity. We're up here in Traverse City, Michigan. Everybody understands the concept of launching a boat. The idea behind launching the boat is to allow for the access for the boat to back into the water, release that boat into the water itself, and remove the trailer and the truck or the vehicle back on land. The problem that exists here is that the parties, when my client went back to begin exercising the right that was specifically granted to him, the neighbors said, you don't have the ability to change the slope of the land because it wasn't specifically in the consent judgment. However, this court, going back more than 100 years, cases starting back from the 1800s even, has said that the standard is when you grant an easement to someone, as the predecessors to the trust did, the Deeroffs, you provide not only the rights that are in there, but also the inherent rights which are incident or necessary for the reasonable and proper enjoyment of the easement. Here, my client specifically negotiated the right to launch a boat into the Tibbetawasi River and or Secord Lake. The only way he can be able to do that reasonably is to be able to alter the slope of the land, to be able to back that boat safely into the water, to launch the boat and remove the trailer and the truck later on. It is my position and my client's position going forward here today that both the trial court as well as the Michigan Court of Appeals both erred in not following the well-established law that reasonable use includes all those rights that are incident and necessary to the party.
Counsel, good morning.
Good morning.
Can you explain to us why is this jurisprudentially significant? Just help me to assuage my concern that it looks like it's error correction, and how is this something that's going to affect a greater number of people than just the individuals that are affected by this case?
Well, Your Honors, I've been before you before on water property cases myself, and I'm a riparian rights attorney that specializes in this particular area of law. When we negotiate settlements and resolutions, we depend on a robust, solid body of law to be able to dictate how those consent judgments and agreements are drafted. And as I mentioned in the top part of my argument, we relied on cases like Harvey and like Black Hawk Development, which established that we don't need to get every fine point detail into a resolution. What we need to get is the understanding of the parties and that which is necessary to be able to effectuate those understandings going forward. Our concern is, and my concern with this case is, this is the case that's going to undo the test of Black Hawk. Black Hawk was a strong reinforcement of the Harvey rule, and this court should continue that. The problem that I see is, and we talk about error correcting in this respect, the Court of Appeals essentially is saying we're not going to follow the Harvey and Black Hawk tests going forward. And that creates exceptions and uncertainty in the law, and it makes it impossible for lawyers like myself, who represent clients who are abutting waterways, to be able to accurately and correctly be able to put forward settlement agreements, consent judgments. And ironically, this was part of a court case, obviously, but these same principles apply directly to the simple drafting of easements themselves. How much detail does a party have to put into an agreement in order for the parties to continue on with those particular rights?
How do you define, I mean, is there a little, help me to understand, is there a sense of vagueness when it comes to the idea of watercraft, the definition of a watercraft? Could it be, I mean, what's the limitation when you talk about a definitional standard of a watercraft?
Well, the Court of Appeals tried to play, I think, a bit with that language, that there was no definition of watercraft, so therefore there's no reasonable or incidental use. Watercraft, to me, as part of this, is given the circumstances where we're at, we're not launching into the Pacific Ocean. We're launching into Secord Lake. In fact, where this particular spot is, as the photographs and the video provide for, is that you could actually probably slingshot a rock across the width of this particular waterway itself. Obviously, we're not launching the USS Missouri out in that particular area. What we're looking for, and what my client has done historically, and as part of the original complaint that's in the court file, is that he launched his personal watercraft. It's an 18-foot boat. It's a normal boat that you would find on a Michigan inland lake and waterway. Now, I would acknowledge that if my client wanted to launch the USS Missouri into this particular area, it would probably be outside the reasonable and proper use for that particular easement of a 20-foot wide space. aircraft carriers are wider than 20 feet. I think that provides a natural limitation for what the intent of the parties were going forward.
Does it matter if regrading, I mean, is there anything in the record so that we know that the regrading that you seek will actually accomplish what your client believes he's trying to accomplish under the easement, and what if it's not?
Well, I give my client a lot of credit for the fact that rather than, in many instances, when two neighbors are fighting, and of course animosity is high, especially coming off of a court case, and mind you, the posture of this case was the second motion for contempt, when the other folks weren't abiding by their original consent judgment. Rather than just bullishly pulling forward and trying to just alter the land and start a second lawsuit, my client reasonably went back to court and said, let's make sure we understand what the nature of this, because I was the trial counsel, and most of the time when I'm before you, I'm not the trial counsel, and this one I am. This was negotiated out the morning of, and as a result, the trial judge worked, and Judge Evans from Gladwin County is a very, very nice man. He works with parties very hand in hand to try to get the resolution on these issues, and he worked through it. And he asked the question to the Deeroffs, which is the predecessor to current parties here. Is it possible to get down to the water's edge? And they said, as it currently stands, absolutely not. Except here's the problem. They specifically granted that right to my client to be able to do that. So, I mean, it's almost inherent in an acknowledgement and I cite this in the court record itself where it's at Appendix 130A, where at the time Deeroff's counsel conceded that as construed at that particular point, it simply can't be used for the purpose for which it was actually granted. So it's a long way to answer your question. We did not put forward any plans at that point because we stopped and said we rather than the parties causing greater animosity with each other, we sought judicial intervention.
Counsel, can I ask you one question,
Sure.
please? I don't mean to sound discourteous. Please don't think me discourteous when I ask this, but had you simply put in a single sentence in this contract having to do with your right to regrade the slope, you wouldn't have had to rely upon litigation, upon the judgment of this court, upon the Black Hawk test. You would have resolved the issue. Why didn't you put that in there?
The short answer is that this is a common customary practice for property attorneys.
It's a customary practice not to be as precise and as specific as you can in the context of an agreement? Let
me give an example of this. Say, for example, that they agreed to put in a gravel driveway. How far down do we have, and that's not the case here, I'm offering a hypothetical, but say the parties in addition to this agreed to a particular gravel, we're going to gravel this particular roadway going forward. How far down the details? Do we have to specify what quality and what details of that gravel?
I understand your point, but you have a conundrum there. I mean, to the extent that you're arguing, as you have already, that this is a pretty obvious aspect of what the agreement pertained to, namely the right to regrade the slope, the more obvious it is, the more obvious it is also that it should have been placed within the four corners of the contract and spelled out in black and white.
Well, however, the nature of the easement itself didn't actually, it left open the wide ability for the neighborhood to be able to utilize this. So whether my client's proposing to use it to regrade the slope of the land to go to the water's edge, just as easily it could be, as Judge Evans indicated in the transcript, you could bring in a large crane and affix a crane to the property and crane your boats into the water itself. Now, myself personally, I think that's outlandish. I think that's not practical for that respect. But the idea here was to leave as much available ability for the parties to be able to effectuate what was specifically agreed, which was the launching of the boats. Many times these types of activities, and we haven't even gotten to this part, requires approval from local municipalities, DNR, DEQ going forward. There may be additional requirements that are also there. In fact, I almost can guarantee you there's going to be additional requirements to do that. What we don't want to do is agree to something specific where, of course, these agencies come back and said, you agreed to something that now renders it impossible to be able to go forward. So we try to get as close as we can to get to the intent of the parties themselves without locking in and jinxing the actual outcome.
Not only did you not put obvious language in the agreement here, But when you speak about the intent of the parties, I'm not sure you're speaking for the intent of the parties as much as you're speaking exclusively for your own intent. Otherwise, we wouldn't have had this litigation, I presume.
Well, I respectfully disagree, because the reason being, if we look to the language of the easement itself, it doesn't say you have the right to walk down to the water's edge. There are agreements I have drafted outside the context of this case where the use of a particular piece of property is merely to walk along, to be a viewing of the lake or a viewing of the water. Here, the language was specific not only for the launching of watercraft. It didn't stop there. It went on to say, by boat trailer. So, and it's to, into, and from the waters of the Tibbetawasi River. How much more detailed can this be in that respect? In the fact that, now perhaps my client needs to go about it a different way, but the arguments that have been presented in the trial court by Deeroff's counsel in this respect is that there's no use other than the land as it currently resides. I would also, if I know, see my light is flashing quickly here.
Up to you, 245.
I'll make one additional point.
242.
One of the issues that have been hard hit on by my opposing counsel is the idea that there is a provision as to damage to the property and how alteration to the, you have to return it back. What we are essentially seeking is an improvement to the property, not a damage to the property. The damage to the property would be considered, and the one I was thinking of at this
But
particular...
counsel, that's actually a really interesting argument, and I was really thinking about that. But it's their property, right? Like it's their property. So doesn't that get a little complicated and challenging? Because if it's my property, you're assuming what is damaged and what is not by making modifications to the property that is not your own. I understand you have an agreement, and we're going to talk about all that, but I mean, it's still a modification that these folks don't obviously seem to want.
Well, however, the 2 points in response to that, one is the case law clearly establishes the easement holder's rights are paramount to the Servian estate. And I know that sometimes we don't like, as the second buyer, what someone else's deal made before us, who was the predecessor owner of the land, but the easement holder's rights are paramount. Second of all, I would also point out that if the predecessor, the Deeroffs, wanted to limit what the reasonable and incidental use was, they could have put a limitation as to what the use of that property was. When they made that deal, they knew the body of law that was in existence at that time was my client, in addition to the specific right that they had, would also provide for the ability for them to have the reasonable...
I just want to ask a quick question, and it's just an equity question. I'm just trying to understand, and it just gives me a more holistic perspective. If you could and this is just for clarification, does your client own another piece of property that gives him direct access to the water?
At the time that this agreement was put into place, they did not.
But he does now,
But
right?
subsequently, he did purchase, another piece became open, which he did purchase.
Okay, and I just want to understand, it just gives me a more holistic approach to this. Why is this important to him? So just to make it clear, he does have another plot of land that gives him direct access to the water. So can you help me to understand why this is so paramount to him at this point?
It is paramount to him because this is the traditional and best way to get to the water because it's a road, it's straight there. But more importantly, we mustn't forget, the agreement, the consent judgment provides not only rights to my client, but provides rights to everyone within that subdivision itself. So as a result, my client is not only standing in the shoes, I don't want to be like they're standing directly in the shoes, but the agreement he actually negotiated was not only for himself the morning of trial.
So is this like, are we to look at this as like an altruistic gesture? Is that, I'm just trying to understand, because he has property that gives him access to the water. Is it your contention that he's doing this as a leader to help the neighborhood?
I want to be clear, when he says he has access to the water, he has another waterfront parcel.
Okay.
Okay,
Does that give him
not the,
access, though?
I'm sorry?
Does that give him access to the water? Does he have access to the water to launch his boat from that parcel?
Not as that property is currently situated. The Bonda Lane property was traditionally the property that was used to access that
Could
particular...
that property give him access to the water?
Well, it abuts the water. Now, whether we give access, I can't speak to that right now because
But
that...
if he made modifications to it, the way he wants to make modifications to this property, could it give him the access he's looking for?
I don't know that standing here today.
Okay.
But anyway, I see my light is on. Thank you very much.
Just one more question,
Yes.
please. What is your legal basis for citing the proposition that one of the party's rights is paramount to that of the other in this context?
I briefed that issue in the I believe Blackhawk even cites that for the proposition.
This court has last spoken on that proposition by saying the use exercised by the holders of the easement, that is, your client, must be reasonably necessary and convenient to the proper enjoyment of the easement with as little burden as possible to the fee owner of the land. I don't think that diminishes your client's rights here, but I don't understand where the proposition comes from that as a default principle, one of the parties' rights should be considered to be paramount to that of the other.
Blackhawk at page 41 provides that the easement holder's rights are paramount. However, the limitation on that paramount designation is that it has to be within the confines of what the parties agree would be the activity in that particular respect. I also cite, it's on page 6 of my supplemental brief, also Harvey holds for that proposition as well. So this is a well-established principle going back well more than 100 years in our state's jurisprudence. Thank you.
Thank you, counsel.
May it please the court, Alex Bomarito on behalf of the Seiler Trust, who unfortunately were the party that kind of bought into this. While the contempt negotiations or contempt hearings were going on without notice from the Deer Office until they got brought in through the Court of Appeals as the current party in interest. I guess I'll comment on Mr. Ellison's, a couple of his comments. I don't think this regrading is an improvement to this area. I think it's an expansion of the easement. This was purely just adding gravel or somehow improving the area such that you could launch or back a trailer down to the water's edge to launch a watercraft. That might be an improvement or maintenance. But this is an expansion. And if you look at I don't think this is a undoing of Blackhawk at all. I think what it is, it's telling lawyers who write these agreements that if you want to launch an 18-foot boat or similar watercraft, that you should put that into your agreement. This watercraft, I could delineate several different watercraft that could be launched from that area currently. I could launch a fishing boat. I could launch a kayak. I could launch a canoe. Even the Court of Appeals asked, well, if you wanted to launch the Titanic, why didn't you put it in there? So I think this is not, what I think happened here is after the settlement agreement was put on the record, it was 2 months of of hammering out the actual agreement. I think what this was an afterthought. This wasn't presented to the trial court until the second motion for contempt, which was nearly a year after the agreement had been entered, I believe in June of 2015. They had the first motion for contempt, which was with respect to a sawhorse and some fencing that was placed in the easement area between the end of Vonda Lane and the waterfront. So it was never addressed at that first motion a month after the judgment or 2 months after the judgment was entered. A year later, they come back to the court in May of 2016, I believe, and say, well, we want to regrade and we want a declaration that we can regrade. And Judge Evans said, no, I don't believe that's what you have. If you look at the specific language of this easement, and Blackhawk clearly stands for the proposition that you look at the four corners of the document, language that's provided in the easement. This was specifically set forth launching of watercraft by boat trailer. And that can be accomplished. If you look at Blackhawk, it says it has to be necessary and incidental to reasonably allow for the use. If you want to somehow expand by application of law, the expansion has to be necessary and incidental. This regrading is not necessary or incidental.
I agree with you, counsel, that watercraft is a broad term, right?
Correct.
It could mean ocean liners.
Correct.
Or it could mean a kayak, right?
Correct.
At either end of the spectrum. But isn't the term limited, as counsel suggested, by the context of the easement, by these concepts like being launched by a boat trailer or being temporarily moored? For example, I don't think you can launch a cruise ship on a boat trailer, right?
Correct.
And I don't think folks, and I guess I don't do this very much, but maybe you can correct me if I'm wrong, but I don't think folks typically launch their canoe or their kayak by backing a trailer into the water either. Aren't those boats usually light enough to be dragged into the water?
I'm not be disagreeable, but I have seen trailers that are set up to haul kayaks and canoes. And they back up close to the water's edge and they take the watercraft off the trailer and launch it into the river.
But why shouldn't I think that launching a boat by boat trailer includes what the plaintiff is suggesting is included within the scope of the easement, just by looking at the four corners of the document, not thinking about the history and not thinking about what the land looks like now and so forth. Just looking at the language here, which I think is where we have to start our inquiry unless we determine these terms are ambiguous. Why shouldn't I conclude that that's included within the scope of launching a boat off of a boat trailer?
If regrading the slope of parcel B at the end of Vonda Lane was necessary for launching a boat via boat trailer, it's my position that should have been put into the agreement. If you want, like I said, if you want to launch an 18-foot pontoon boat or pleasure boat.
You weren't there at this negotiation, right?
Correct.
But doesn't your position amount to an assertion that there was no meeting of the minds?
No, I think there was a meeting of the minds. And if you look at the discussion that Mr. Carey, the counsel for the Deeroffs, had at the second motion for contempt, his explanation was this was supposed to be a neighborhood drop-off area where you go back in, drop your boat off, and then launch it into, and it was for kayaks and things like that. I think what happened was when the agreement was being the consent judgment was being written after the settlement agreement was put on the record, somebody said, well, we didn't talk about this regrading. And it's interesting to note that in the first motion to for contempt, there was discussion about this little silt fence and a sawhorse that the Deeroffs had placed at the end of Vonda Lane, and their explanation was, we want to put it there because we don't want people to come down Vonda Lane and all of a sudden drive into the Tittabawassee River. And Mr. Maniaki's counsel said, well, if they wanted that sawhorse language in there, then it should have been in there. So it's somewhat cutting against the argument that he's presenting to the court.
Should it matter to us at all what these arguments were at these subsequent hearings, or should we just be focused on the plain language of the easement agreement?
Probably yes, on the plain language of the agreement. But if launching of the watercraft necessitated regrading of the easement area, it should have been in the agreement. What I'm saying is...
Counsel, doesn't case law provide us that? I mean, the question is the use expressly provided for? The use being launching a watercraft by a boat trailer. And then the case law, the existing case law, Little versus Penn and Blackhawk provide us that when the use is expressly authorized, the means or the improvements by which you are able to effectuate that use such that they're reasonable and necessary to effectuate that use. I mean, why would it have to be specified? Why would every sort of thing have to be specified if the law for years has been, as long as the use is expressly authorized, then we have the means to figure out what's reasonable and necessary to effectuate that use?
I don't think we're modifying the law at all. I think if you look at the language that is used, it's launching of watercraft by boat trailer. And I'm saying you can do that today. That this alteration is not necessary and it's not reasonable to the fee holder. If they want, like I said, if they wanted to say, I want to launch an 18-foot pontoon boat or pleasure boat or similar craft, where they kind of gave them a little wiggle room, that should have been in the agreement. I don't think regrading of the easement area was something that was bargained for at the time of entering the settlement agreement on the record or when the consent judgment was finalized and entered by the Gladwin County Circuit Court.
Counsel, do you agree that the definition of launch is to set a boat or a ship in water? That's the definition I find when I look it up in a dictionary.
Correct. I don't disagree with that, but I could say that you could launch a watercraft as it's currently situated.
Right now, you can set a boat in water by boat trailer?
I can set it to the water's edge by boat trailer.
But the agreement says launch, set a boat in water, including by boat trailer. So my question is, what is your position on whether that's possible right now? Can you set a boat in water by boat trailer?
I would say you could not. I mean, I'm not going to disagree with the fact that you would have difficulty
Looks
placing
like
a
it from the
boat
photos.
trailer in there, but like I said, I don't think that, when they included the term watercraft, I understand they were trying to be broad, most likely. Again, I wasn't there. But if you, like I said before, if you wanted to launch a multi-foot pontoon boat or pleasure craft, that should have been in there. Or you should differentiate between a kayak or canoe or a pleasure boat. With the term of watercraft, the way the document's written, if you look at the clear and ambiguous language of how the document's written, everything in that easement can be accomplished currently without any alteration. And that going to another point.
Well, except you just agreed with me that you cannot set a boat in water by boat trailer. You can't accomplish that.
I cannot back a trailer into the water the way it's currently situated. But I think going to the unreasonableness of this regrading, as counsel indicated in his argument, you would have to go get DEQ or Department of DEGL now, the Department of Environment, Great Lakes and Energy, approval to do that. And if there was a regrading without that approval, or county approval, or whatever other approvals might be necessary, they're going to come to the fee owner. They're not going to come to the neighbors in this resort area, the subdivision, essentially, and say, well, you guys regraded this, but it's Mr. Seiler's property. They're going to come after Mr. Seiler. So they're either going to force Mr. Seiler to participate in this approval process because he's the fee owner, or he's going to be left holding the bag with respect to any liability that might occur. And this is especially noted, and I don't even know if council knows this, but it's my understanding that Mr. Maniaki has both of his parcels that are in this development for sale currently. So, he sells his parcels, my people potentially get left holding the bag with respect to any DEQ liability or Department of DEGL, now that they've renamed
Council,
it.
assuming that if we were to find that the ramp or that the use of launching by boat trailer is specifically authorized in the easement, and that it is necessary in order to effectuate that use to construct a ramp, what's the best argument that you have that constructing a ramp or regrading would unreasonably burden your client's estate?
Well, as I was just saying, it would require them to participate in any permitting process.
And that's an unreasonable burden?
Correct. And they're going to have to apply, or somebody's going to have to apply in their name.
But why is it unreasonable when they granted the easement?
Well, it was predecessor in interest that granted the easement. I know it applies to them, but
Exactly. When you buy the property, you understand that there is an encumbrance.
But again, if that was to be written, if that was the agreement of the parties, it's my position that that language should have been in the consent judgment, and the language regarding maintenance and maintaining the status quo completely cuts against that position. I mean, the maintenance says it's the fee owner's responsibility, right and responsibility to maintain that property. Unless you rut it up when you're launching a boat by boat trailer, then the person who used it is responsible for repairing that and returning it to the status quo. And it's our position that if they want to alter it every time they pull the boat back out, pursuant to that language, they're going to have to put it back to the status quo way it is right now. So it's effectively a circular position. I'm going to put my boat in. Excuse me?
Is the return to the status quo part of the written easement, or is that
The written
extraneous to the easement?
Maintenance language says that any persons creating the damage shall be responsible for restoring the easement to its pre-damaged condition, pre-damaged state. So is this going to be a situation where you, as Justice Bernstein said, who's going to define damage? So they excavate this out, they regrade the road, they put in the boat, they pull out the boat. Well, if it goes to its pre-damaged state as set forth in paragraph 4 of this consent judgment, Somebody's got to fill it back in. And is this going to continually happen? That's what I think that paragraph cuts against the argument
Are
that
you
this was
equating
agreed
the
to.
improvement, a reasonable and necessary improvement to effectuate the expressly granted use of the property, that is the equivalent of damage to the surface of the easement?
I believe so. Because who's to define damage? They're the fee owner, and I understand they have a right for ingress and egress of launching a boat, including by trailer. But I think that
By
language.
boat trailer.
By boat trailer. But I think paragraph 4 cuts against the argument that this was understood by the parties. Because it clearly says you're gonna return it to the pre-damaged state. What that tells me is that if I back my boat trailer up or my truck up or whatever vehicle I have to launch a boat with or without a boat trailer, and I damage the area of the easement in some form, that I'm responsible for fixing the ruts or whatever damage I may incur on that property. So if I'm the property owner, I'm going to argue, such as my clients, that if you excavate this area out, that's damage to my property. That's not part of this easement. That's not part of what was agreed to by the predecessor.
Any further questions? Thank you very much, counsel. The case will be submitted.